we have a brand new court decision out of the Supreme Court of Minnesota where they appear to have created an entirely new and novel category of the legal duty to retreat. America's self-defense law doctrine and principles is many hundreds, arguably thousands of years old, but in the more recent context of history, hundreds of years old from Old English common law, and hundreds of years ago, the most common weapons that people might use to engage in confrontation were contact weapons. Firearms were not common. Projectile weapons were not convenient to carry around. So we're talking clubs, saps, knives, fists, feet, things that have to be brought into proximity of the intended target in order for injury to result. If that's the world in which you live, arguably a duty to retreat may make sense. A generalized legal duty to retreat, if possible, with complete safety before you can resort to deadly force in self-defense. Because in the context of a contact weapons only world, if you can create a few more feet of distance, you're effectively outside the reach of that contact weapon. And no life-taking confrontation has to take place. And of course, our concept of the state and the individual were different in those days. Everyone was a servant of the crown, essentially, and the crown did not want its people killing each other if it could be safely avoided. Now, in the more modern era, especially in America, where guns are thankfully commonplace, retreating begins to not make much sense. If someone is threatening you with a gun unlawfully, you don't get much safer by attempting to retreat because you can't outrun a bullet. That's not going to happen. So in America, the majority position among the states has always been that there is no generalized legal duty to retreat before you can use deadly force in otherwise lawful self-defense. So today there are only 11 states out of 50 that impose a generalized legal duty to retreat before you can use deadly force in otherwise lawful self-defense. 39 states are stand your ground states where you don't have that legal duty to retreat before you can use deadly force in self-defense in otherwise lawful self-defense. Whether it was practically possible is a judgment call that's going to be made by other people. Your legal outcome is not decided by you. It's decided by responding police, investigators, prosecutors, judges, jurors. They're the ones that are ultimately going to be making the controlling judgment call about whether you had a safe avenue of retreat. Remember, every one of these 5 elements of self-defense, these building blocks of self-defense, they're cumulative. All the required elements are required elements. The state does not have to disprove your claim of self-defense in its entirety. The state merely needs to disprove beyond a reasonable doubt any one of the required elements of self-defense. If they do that, your conduct, your use of force simply was not self-defense as a matter of law because you're missing one of the required elements. From a prosecutor's perspective, that means each of these elements is a target of attack because they know if it's a self-defense case, you're not saying it wasn't me, I didn't do it, I didn't shoot that guy. You're saying it was me, I shot him, but I shot him with the legal justification of self-defense. So the prosecution knows if they can defeat your claim of self-defense, they have a walk-away conviction because you've already confessed to the underlying conduct. You're not denying the underlying conduct that you shot the person. So the whole focus of the prosecution is attacking one of these required elements. Now, in most states, 39 states, the element of avoidance is not on the table. Avoidance, of course, having to do with this duty to retreat, because in 39 states, there is no generalized legal duty to retreat. In those stand your ground states that don't impose a legal duty to retreat, and generally you can stand your ground if you're in a place you have a right to be, you're not acting unlawfully, and you're otherwise acting unlawful self-defense. So you're the victim of unlawful aggression and so forth. In those 39 states, effectively what they're saying is so long as you have the other 4 elements of the 5, so long as you're the innocent victim of an unlawful attack, and that attack is imminent, either actually occurring or immediately about to occur, and you're using proportional force in self-defense. You're not using deadly force in self-defense unless you're facing a deadly force threat, and your perceptions, your decisions, your actions in self-defense are both subjectively and objectively reasonable. If you have those 4 elements of self-defense, they're not going to put you in a cage for the rest of your life because some sweet-talking prosecutor managed to convince the jury that maybe you had a safe avenue of retreat that you didn't take, which of course none of them know. None of these people, the jurors sitting in a jury box in complete safety, not under attack, they weren't there having to both defend themselves from admittedly life-threatening attack, right? Remember, the other 4 elements are all assumed to be present here, and at the same time trying to look around and see if there was some kind of safe avenue of retreat. The stand your ground states are saying if you have those other four elements, innocence, imminence, proportionality, and reasonableness, we're not going to put you in prison over avoidance. The duty to retreat states say even if you have those other four elements, even if you are unquestionably, we concede that you were the innocent victim of unlawful attack, that attack was imminent, actually occurring or immediately about to occur, that attack was deadly in nature, and that everything you did was otherwise reasonable. We reserve the right to put you in a cage for the rest of your life if we think we can convince a jury that there was a safe avenue of retreat that you failed to take. That's the public policy difference between the stand your ground states and the duty to retreat states. And now Minnesota appears to be taking a step in the other direction by further constraining your ability to defend yourself by expanding the duty to retreat. Now, traditionally, how the duty of retreat was applied is if you used force and you were criminally charged and you claimed self-defense in a duty to retreat state, one of the targets of attack for the state was avoidance, that you failed the legal duty to retreat. But that target was only available to the state if you actually used force against that other person. You shot them. You stabbed them. You dropped whatever, a piano on them from a great height. You use deadly force in self-defense. Then they get to examine retrospectively, well, was there a safe avenue of retreat that you failed to take? Are we able to attack that element of avoidance? Never before has any duty to retreat state attempted to make that argument that they should have the privilege to attack your claim of self-defense on the element of avoidance if all you did was display a defensive weapon as opposed to actually use the deadly weapon. And that's the point of this Minnesota decision where the Minnesota Supreme Court says, nope, moving forward, the legal requirement in Minnesota is that you have that legal duty to retreat even if all you do is display a defensive weapon, and the prosecution is free to attack your display as being unlawful on the element of avoidance, that you failed to take advantage of that safe avenue of retreat, which obviously has a lot of implications. Now, the case we're going to read about here, the defendant was charged with assault. He threatened a number of people with a machete. He's claiming self-defense. But remember, this newly created law, and by the way, when an appellate court like this, either a mid-level appellate court or a state Supreme Court does this, creates a new legal standard, it's as much legitimate law in the criminal justice system as is any statute passed by the legislature and signed by a governor. There are really two authoritative sources of law. The first is legislative, which we're all used to, statutes. But the second is case law created by the appellate courts. It's one of the reasons that if all you've done is read the statutory law on use of force in your state, you don't really know what the use of force law is in your state because you've only read the half that's statutory. Statutes don't have any force in the real world by themselves. They're just words on a piece of paper. Statutes have no effect in the real world until they are interpreted and applied by courts to real people in courtrooms. This is the decision handed down July 31st, so 2 days ago, from the Minnesota Supreme Court. This case presents a narrow issue of first impression, whether the duty to retreat when reasonably possible, that means safely possible, a judicially created element of self-defense long established by our court, that means it's not a statute, it's created by case law, applies to a person who claims they were acting in self-defense when they committed the felony offense of second-degree assault fear with a dangerous weapon. So to clarify here, folks, assault is when you put someone else in fear of harm. Battery is when you cause the harm. So when we're talking about assault, we're talking about a threat of harm. For this decision, a dangerous weapon is limited to a device designed as a weapon and capable of producing death or great bodily harm, meaning any tool that a normal law-abiding person would use for lawful self-defense. A lawfully carried gun, a lawfully carried knife, pepper spray. Appellant early Romero Blevins pulled out a machete on a light rail platform in downtown Minneapolis and brandished it at a woman and two men for nearly 1 minute with the specific intent to cause them to fear immediate bodily harm. Based on this conduct, the state charged Blevins with 2 counts of second-degree assault, fear with a dangerous weapon, a felony-level offense. The legislature has deemed the act of committing assault, fear with a dangerous weapon to be harmful with a maximum punishment of 7 years. Even for a person with no criminal history, the presumptive sentence for second-degree assault fear with a dangerous weapon is a prison term of 21 months. Blevins waived his right to a jury trial. So this was a bench trial at the trial level. No jury. A judge played the role both of judge, finder of law, and as jury, finder of fact. So the judge's fact finding here is as controlling as if it were done by a jury. At his court trial, Blevins claimed his actions were authorized under Minnesota statutes Section 60906, which is their self-defense statute, which allows a person to use reasonable force upon or toward another when resisting an offense against the person. In a case that involved the claim of self-defense to a charge of felony second-degree assault harm with a dangerous weapon, so just threatening, not using, we said that the reasonable force authorized under Section 60906 may be used only in the absence of a reasonable possibility of retreat to avoid the danger. Again, court-created law by the Minnesota Supreme Court. After considering the evidence presented at trial, the district court, the trial court, found that Blevins committed the felony offense of second-degree assault fear with a dangerous weapon, and consistent with our case law, the court concluded that Blevins' actions in threatening, not using, threatening others with his machete were not authorized under that self-defense section because he had a reasonable opportunity to retreat and failed to do so. The Court of Appeals affirmed the conviction, and then Blevins applied for Minnesota Supreme Court review, which they obviously granted. For the reasons described below, based on the specific facts presented here, the brandishing of a machete, we now narrowly extend our judicially created self-defense element that imposes a duty to retreat when reasonably possible to persons who committed the felony offense of second-degree assault fear with a dangerous weapon, specifically a device designed as a weapon and capable of producing death or great bodily harm. So mere threat of the use of a deadly force defensive weapon. In doing so, we need not and do not decide whether this judicially created duty to reasonably retreat applies to other charges of assault fear, but they reserve the privilege of doing so, and you only find out after the fact. Remember, this is new law. So this defendant Blevins, he had no reason to know that his mere threat of a defensive tool, a defensive weapon, would be judged as vulnerable under the element of avoidance. He had no reason to know that. That wasn't Minnesota law. They're applying this law effectively, retroactively to Blevins. Can't do that with a statute. That would be unconstitutional. But they do it with case law all the time. Accordingly, we hold that a person claiming self-defense has a duty to retreat when reasonably possible before committing the felony offense of second-degree assault fear with a dangerous weapons. We also conclude that when viewed in the light most favorable to the verdict, the direct evidence from the security video presented at trial disproves beyond a reasonable doubt Blevins' claim that it was not reasonably possible for him to retreat. We therefore affirm the decision of the Court of Appeals. So his conviction stands because he didn't abide by a rule that didn't exist at the time of his conduct. The legislature has also described great bodily harm that limits the types of devices that are considered to be dangerous weapons. Great bodily harm means bodily injury which creates a high probability of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. So important concept, deadly force includes force not just that can kill you, but effectively that can maim you.